So welcome to the Resolution Room. So today, ethics in negotiation and mediation. Although ethical rules have been developed well in the context of, say, a practitioner's obligation to a court, there's far less guidance in many respects on the obligations that a practitioner owes, particularly to their opponent, say, in the context of a negotiation or mediation. And I think sometimes there's a false premise. Court is where it all gets very serious, but that negotiation is just a game. And it's a game where every person is for themselves. You've got to rely on your own information. You don't rely on anything really the other party says unless it's verified by yourself. And it's really just a very strict application of that old classic principle at law school, caveat emptor, or the buyer beware. So it's every person for themselves. But of course, it's not true. Negotiation is not a game. It's not an ethical free zone. It's not an honesty free zone. There are important ethical constraints that apply to the negotiation context itself and to practitioners. I'm just going to ask a rhetorical question first before we get into it, and that is, have lawyers hijacked the promise that was mediation? Now, I say that from an historical perspective because mediation first arose aiming to be transformational. In other words, changing people's view on conflict, getting people to talk more directly, ensuring people were less adversarial and could have some reflection. So that's kind of the context in which mediation arose. But then in the history of the legal industry, in about the 80s in particular, it really took off in the legal industry because with a very busy court book, it was found to be a very effective way to manage litigation as well. But I just throw that out there that it wasn't at first intended to be used as commonly as it is now being used by lawyers. So we all know the ethical obligations that lawyers owe to a court. So let's break it down. There's obviously an obligation not to mislead. You don't have to necessarily point out an error in your opponent's submission, but there is an obligation not to mislead on matters of material fact and law, for example. Let's look at some other obligations. There's an obligation, of course, to a client, and that is to provide competence, to be candid, to protect confidence. But that's not an absolute obligation to protect confidence because, of course, there are obligations of disclosure of material that may be adverse to your case. And then, of course, there's the obligation or duty that you owe to an opponent. And this is particularly important in the negotiation context. Where conflicts arise, in my view, and I'll explore a case that gives a classic example, the conflict arises between the duty you owe to a client to advance their case robustly and the duty that you owe to an opponent not to mislead and to be candid enough. Before I talk about the case that I want to go into, because it's a Queensland case and it's important to keep in mind, I want to first of all touch on the solicitor conduct rules because they set out the obligations to an opponent. So bear with me while I quote it. A solicitor must not knowingly make a false or misleading statement to an opponent in relation to a case, including its compromise. And you must take all reasonable steps to correct, this is really important, any false or misleading statement as soon as possible after the solicitor becomes aware that the statement was false or misleading. There's another rule here, a little cute rule. The solicitor will not have made a false or misleading statement to the opponent simply by failing to correct an error on any matter stated to the solicitor by the opponent. So you can see some nuance there, but really important is you can't make a knowingly false or misleading statement. Of course, the question then becomes, what is a misleading statement and what is puffery? The notion of puffery, of course, is permissible in the sense that you might overstate the strengths of your evidence or you might amplify the strengths of your evidence. That's quite fine. But where it becomes misleading or where it goes beyond the ethical realm is where there is no, of course, reference appropriately to the evidence at play. That's where you've got to be very careful. So, for example, it's okay to talk, if you're for a plaintiff, about the high watermark of your evidence, and it's quite okay for a defendant to conversely talk about the low watermark, but it really needs to be very careful, evidentially based. And that's generally done, I might add. And if you do that, you won't come into any ethical dilemmas. Now, the case that I want to cite is a case that again plays out that conflict, the conflict to a client and the duty to an opponent. So it's a case involving a barrister by the name of Mr. Mullins. Mr. Mullins was briefed in a personal injury claim, a motor vehicle accident claim. It was all systems go to a conference. It was quite a serious injury, actually. All the medical and other evidence had been obtained. And a couple of days before the conference, the plaintiff advised that he'd been diagnosed with cancer, and this was apparent on the records as well. Mr. Mullins first thought appropriately that that's something that needed to be disclosed, but the client said, no, I don't really want to disclose it unless I have to, and I want you to research whether I need to disclose it or not. And Mr. Mullins went away, looked at some law and spoke to a senior barrister. He relied on a particular provision in the Motor Accident Insurance Act which said that you had 30 days from the receipt of information to disclose it, and arrived at the view that because the conference was being held before that 30 days, in a couple of days, he wasn't required to disclose it. So what happened was the conference went ahead. Mr. Mullins just carefully said that he relied on the medical reports and other accounting evidence at play, and the matter settled. And then the insurer brought an application to set the settlement aside on the basis that it was effectively induced by misleading statements because, of course, the future economic loss claim was premised on the injury affecting the claimant's capacity as opposed to this intervening, if I can call it that, cancer diagnosis. Now, what happened in that case was that Mr. Mullins was fined, and there was a determination made that negotiation is not an honesty-free zone. And that's really important about material statements, and particularly statements of fact or evidence. They need to be grounded on the evidence and honest, because you do have that duty to your opponent. There is an important exchange of information on which you rely. Now, begs the question, what should have happened in that case? A couple of things. First of all, Mr. Mullins and his legal team should have told the plaintiff that it needed to be disclosed and get him on board with that. That was their ethical obligation. And then, of course, the conference would need to be adjourned. You'd need to withdraw the medical reports, and you need to go back to the drawing board and reframe the case. Now, if the client says, no, I instruct you not to do that, you would then probably have to withdraw as a solicitor on the record saying, I can't act in that way. And of course, that didn't happen here. And of course, as we know, Mr. Mullins is a very decent, good practitioner who remains in the profession and very competent. But there's a good salient example about the importance of honesty in negotiations on matters that are material. And it's often forgotten that the solicitor who was also involved, who briefed Mr. Mullins, was also fined for professional misconduct as well. It wasn't a defence to say that he relied upon the advice of counsel. I think that case highlights a couple of key learnings. If you think you're being too cute and relying on technical legislative provisions and it just feels a bit off, it invariably is. And I think that's another key lesson, if I could break it down that simply, from that case. So that's about the conflict that can be at play between an obligation to an opponent and an obligation to the client. And that's why, in the context of all negotiations as lawyers, it is not an honesty-free zone. You need to have regard to ensuring that you're not misleading on material matters. You need to be very careful. As a solicitor in the arena, when I was in the arena, say, for example, there was a future economic loss claim that was significant, and there was some information that there may have been a restructure or it may have been on the cards, I'd be very careful about making any statements about ongoing work or things of that nature. I was very careful. And if I knew that it would involve this claimant, the question then was, of course, it needed to be disclosed. But usually it didn't get to that point. I never had to kind of get to that point. But you needed to be alive to really being ensured that I wasn't seen to be misleading an opponent about, say, the longevity of someone's employment. If there were perhaps some friction or some moves afoot or something of that nature, I was particularly careful in that space. So that's ethics in negotiations. It's very broad brush. It's intended to be. It's intended to come at it from the perspective of lawyers, particularly the mediation work I do in the personal injury arena. This is a topic that is a long topic for another day. I do an hour-long presentation on this because, as I say, I don't think we speak enough about the ethics that are applicable in the negotiation and mediation context. And another topic that I cover off on quite a bit in an hour-long presentation is the obligation of good faith, what that means and what that doesn't mean. And it reminds me a bit of the model litigant principle. It's apparent when it's flagrantly breached, but it's otherwise a bit nebulous to define. So I also look at notions of good faith. And I might conclude by saying There is limited material on this subject, and in fact the Uniform Civil Procedure Rules don't really assist practitioners much anyway, other than the registrar has the power to order a mediation or the parties can make application. Then there's a requirement for a certificate, there's a requirement for parties to participate, but the rules don't otherwise state what the requirements are in any great depth. The best you can point to from the perspective of solicitors is the solicitor conduct rules that I've cited, which are pretty clear. So there you have it, guys. Ethics in mediation and negotiation is far from an honesty-free zone. There is an information dependence, and you need to treat your opponent accordingly and carefully. So I hope you enjoyed it. That's just the highlights. Tune in and contact me if you want the longer, more detailed version. I hope you enjoyed this week's episode of The Resolution Room.